What we focused on for the past couple of sessions is how historically society has marginalized those individuals who are not heterosexual. I've talked about many of the main times in history when heterosexuality has been defined as the norm, and I've also discussed how these individuals, those individuals who did not fit that pattern of sexual activity, have been marginalized by society. Today's session is going to discuss the issue from a more political perspective, and we're going to consider what rights are being recognized for those that don't fit into the mainstream model of sexual orientation. The gay movement took hold in the 1970s and it grew in the 1980s. By 1987, the U.S. Supreme Court had heard the case of Bowers versus Hardwick. Michael Hardwick had unpaid parking violations, and a summons was issued for him to appear in court. So when the police went to his house to serve that summons, Hardwick's roommate ushered the officer to Hardwick's bedroom, and there the officer happened to see him engaging in sodomy. Hardwick was fined a nominal amount, but he fought the case and he took it up to the U.S. Supreme Court. He relied on the ruling in Roe versus Wade, that was the famous abortion case from 1972, and he claimed that he had a fundamental right to engage in sex. By a 5-4 majority, the U.S. Supreme Court upheld the Georgia statute, meaning that they refused to find the sodomy statute in Georgia unconstitutional. 16 years later, the U.S. Supreme Court revisited the issue. Now before, in the Hardwick case, the U.S. Supreme Court had decided that homosexual relationships should not have the same protections as heterosexual sex because the relationship was not closely related to reproductive activity. By 2003, when the Lawrence case was heard, the majority then ruled that, and I quote, states should not seek to control personal relationships that were limited to the confines of the home. The U.S. Supreme Court did recognize the history of protecting marital relations and that the early laws were trying to prohibit only non-procreative sex. However, the High Court also recognized that there was a stigma that was associated with criminalizing homosexual conduct. So they struck down the sodomy laws under the idea of what's known as due process. About the same time that the Lawrence case was making its way up to be heard in the High Court, the U.S. Supreme Court, the issue of same-sex marriage started to evolve. Hawaii was the first state to address the issue. In 1993, the Hawaii Supreme Court ruled that the laws that denied same-sex marriage violated equal protection, meaning that all people should have the same protections under the law. That's what equal protection means. This meant that the trial court would rehear a former case, and after hearing testimony from many experts on childhood development, the trial court found that there was, quote, no compelling reason, unquote, to deny same-sex couples marriage licenses. Essentially, the evidence at trial showed that children raised in same-sex households were just as emotionally and psychologically healthy as the children that were being raised in heterosexual households. But as a backlash to this decision, in 1998, the voters then adopted a constitutional amendment that gave the legislature the power to limit to whom they would grant licenses. And so then, at that point, same-sex couples could not legally marry in Hawaii. By the year 2000, Vermont had then passed legislation that would allow same-sex couples to be granted a civil union by statute. Vermont at this time was unique because they had what was known as a common benefits clause in their constitution, and it was this clause that allowed the legislature the authority to pass the laws that recognized civil unions between same-sex couples. The next state to address this issue was Massachusetts. In 2003, the Massachusetts Supreme Court ruled that barring same-sex couples from civil unions was unconstitutional. The opinion in this case very clearly stated that, quote, segregating same-sex unions from opposite-sex unions cannot possibly be held rationally to advance or preserve the governmental aim of encouraging stable and adult relationships for the good of the individual and community, especially its children. Now, what you have to understand was that each of these states was having to fight against the federal law that had been enacted in 1996, and that would be under President Clinton, who signed this law into effect. This was DOMA, the Defense of Marriage Act, and it was a federal law that stated that the federal government did not have to recognize same-sex marriages nor confer any rights. This is a huge issue, that rights associated with marriage or civil unions do not have to be granted. DOMA permitted any state that wanted to deny recognition of same-sex marriage to do so. Now eventually that would be overturned. And be sure you get this in your notes because it's not on any of the slides. But in 2013, the U.S. Supreme Court ruled in United States v. Windsor that it was unconstitutional for the federal government of the United States to deny federal recognition of same-sex marriage licenses if that marriage was recognized or performed in a state that allows same-sex marriages. 2 years later, in 2015, the U.S. Supreme Court ruled in Obergefell v. Hodges that state-level bans on same-sex marriage were unconstitutional as well. It legalized same-sex marriage throughout the entire U.S., and of course we all know what followed from that, the situation in Rowan County, where County Clerk Kim Davis then refused to sign marriage licenses. Ultimately, a federal judge found Rowan in contempt, and she went to jail, and the gay couple in Rowan County eventually was granted their marriage license by a deputy clerk. So even though I did not put it in the course pack, you might want to take a note or two about the Windsor and the Obergefell case, and jot down Rowan County as a place of infamy in the battle for same-sex marriage. So we'll skip the next slide too, because truthfully, so much has changed since the Obergefell decision in 2015 that is truly not very relevant. But what I do want you to think about more is what is at issue in regards to marriage entitlement and rights. What both Windsor and Obergefell considered was that same-sex couples were being denied things like insurance benefits, leases, inheritance, adoption, and hospital visitation. I'll discuss a couple of the famous instances that involve these kinds of issues, where couples had to battle the court system specifically because they could not have the same rights associated with same-sex marriage. But before we get to those, I want to just speak quickly to the idea of same-sex harassment and also what's happened with the Boy Scouts. We are all familiar with the concept of sexual harassment, that it's illegal to either have a hostile environment or to allow quid pro quo, meaning something for something, i.e. requesting sexual favors or activity. But then this begs the question whether same-sex harassment should be illegal. In 1998, the U.S. Supreme Court heard On-Call v. Sundowner Offshore Services, a case where a married, assumedly heterosexual oil rig worker was being severely harassed by his coworkers. So, from my own personal perspective, by someone who litigates cases, I'm always aware that sometimes it's important to have what you would call a sympathetic plaintiff. It's clear that the case was specifically chosen because the oil rig worker was the picture of masculinity and a stereotypical family man. This was a case most likely more about hazing, but the fact of the matter was that it involved typical kinds of sexual harassment. So the result of this case was that the U.S. Supreme Court found that same-sex harassment was actionable and it was against the law. Now we get to the Boy Scouts of America, which has been in the news the past couple of years, but was actually heard by the U.S. Supreme Court back in 2000, 13 years before they would eventually change their official policies. So recently, the Boy Scouts of America, and by recently I mean 2013, decided to end their ban on gay leaders. 13 years before this policy change, the U.S. Supreme Court heard a case which looked at two issues. One, could the Boy Scouts of America ban homosexual members? And two, could they ban homosexual leaders? In 2000, the U.S. Supreme Court decided that the Boy Scouts of America could not ban gay members, but that they could ban gay leaders. However, as times change, fast forward 13 years to 2013, and the Boy Scouts of America has officially changed their policy to allow for gay leaders in their organization. So let's go back now to this idea of what rights are associated with marriage and give you some examples of individuals who had to fight for these rights before same-sex marriage was recognized. First, there is a case in New York where Michael Braschi was living with his partner, and the partner died of AIDS. This was in 1989, and in New York, rent control was a big issue. It keeps landlords from hiking the rent when existing tenants remain in the building. Michael's partner held the lease, and of course the landlord wanted to evict Michael so that he could hike the rent and get as much money as he could from the next tenant. Had Michael been married to his partner, he would have been allowed to stay, and the rent control would have been automatic. Eventually, Michael's right to stay in the apartment would be affirmed by the New York Supreme Court because they found that he had been in a relationship that had been long-term and had all the characteristics of a marriage. So through a long legal battle, Michael Brashy was able to assert his right to maintain his lease. There is a case also that made national news, with Sharon Kowalski and Karen Thompson. This couple had been together for 4 years and had exchanged rings and named each other on their insurance policies. Sharon was injured in a car accident, and she was severely brain damaged and disabled. When her parents went to visit her in the hospital, her father discovered she was partners with Karen, and he forbid her visitation at the hospital. The father was court-ordered to be Sharon's guardian, even though she had been in a long-term relationship with Karen, and had done many of the things a married couple would have done. Karen appealed, but it took many years, from 1983 till 1991, for her to win the right to visitation. She was eventually appointed, though, to be Karen's guardian. A huge issue also has been adoption. Some states have specific bans on who can adopt, for example, Florida. Now, I want you to disregard the information on what states have active laws in the slides, because that is so quickly changing now in response to Windsor and more recently Obergefell. Some of the students in this class, I'm sure, will do the wiki on same-sex marriage, and they'll probably give us all a much better update on the status of this issue. But the main point here is that without the ability to marry in some states, it's difficult and perhaps impossible to adopt children. There are two situations where a same-sex couple might want to adopt. For two people that are both childless, they might want to adopt a child through an agency. But there are also situations where the couple may want to adopt each other's children. Married heterosexual couples do this all the time, but without the ability to marry same-sex couples, they can encounter problems in some states adopting each other's children. So in sum, to think about the changes regarding same-sex marriage, we might want to realize that the nature of the family has changed overall, and it continues to change. The Kodak family, it's a rarity these days, and only 24% of families have both a mother and a father in the household. Now, traditionalists believe that children do better in two-parent heterosexual households. Studies show this is simply not true. The most important factor in a child's emotional and psychological health is how that child interacts with his parents, and that matters much more than a parent's sexual orientation or what sex partner they choose to be with. Many groups that are concerned about child welfare have weighed in on the side of same-sex marriage, such as the American Association of Pediatrics. They take the position of supporting gay and lesbian couples adopting children.